page 2. This is Mr. Montoya's first interaction with.
Just one moment. Excuse me, counsel. If you
Welcome to Global News Desk. Please like this video, subscribe to our channel.
8 State versus Nathan Tyler Montoya. Can I have parties announced for the record for the state? Defense.
David Andre.
Please run the record.
David Andre Woodard for Mr. Montoya.
And are you Mr. Montoya?
Yes, Your Honor.
All right. You entered a plea to the lesser included offense of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you applied for deferred adjudication. According to your plea bargaining agreement, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,500 fine. The state is opposed to your applications. This will run concurrent with County Court Cause number 734433. There should be Chapter 62 registration and no contact with the complainant. Have both parties had a chance to review the TAP evaluation and PSI report, state?
Yes, Your Honor.
Defense?
I have, Judge.
Any objections to the TAP evaluation or PSI, state?
Not Judge.
Defense?
No, Your Honor.
All right, state, you are opposed. Do you have any witnesses?
We do not, Your Honor. In lieu of the witness, we do have a letter from one of the witnesses, well entered in State's Exhibit A. I believe there's no objections.
No objections, Judge.
We'll reserve our argument.
All right, then the court will accept into evidence State's Exhibit A if both parties will give me a chance to review it. All right, if you'll give that to the court reporter.
Yes,
Thank you. And if you could, I think it's marked on the inside as State's Exhibit, correct?
it is.
All right, defense, do you have any witnesses?
No, Your Honor. Only argument.
All right, then the court will hear argument. State, you are opposed?
We are opposed, Your Honor, but we'll reserve.
All right, defense?
First off, Judge, looking at the PSI on page 2, this is Mr. Montoya's first interaction with.
Just one moment. Excuse me, counsel, if you, Ron, if you all could just move to the other end. Hi, if you could just move to the other end, we're on the record. No problem. You are counsel. All right, we're back on the record. And counsel, what page did you say?
I'm on page 2, Judge, of the PSI regarding Mr. Montoya's criminal history.
Yes.
The only criminal history that he has, Judge, is this current case and also the misdemeanor case that's going to run concurrently with this case. Aside from that, he has no prior criminal history. He's 30 years old. At the time of the incident, he was employed at Amazon. He was working. This case was resolved fairly quickly, Judge. Mr. Montoya accepted responsibility fairly quickly. He took a plea, and now we're here before the court. Since he's been in custody, I believe since May of 2024, he's had no contact with his brother, who drafted the letter, I think, for the State's Exhibit number A. And he's also had no contact with the young, who is his niece. Speaking with him, he realizes what he did was not only wrong and inappropriate, but was also a criminal offense. Also, there's a TAP evaluation that is the last page of the PSI report. And the TAP evaluation does not show that Mr. Montoya has any substance abuse issues or any alcohol related issues. We are asking the court to grant his application for deferred. I know it's a difficult case for courts to consider granting a person deferred adjudication. We're asking the court to give Mr. Montoya that opportunity, one, because he has been in custody. He's had time to reflect and to think about what he did, not only what he did, but the repercussions that happened with his niece. Looking at the PSI and also the letter that the state submitted, it does look like the niece did go through some mental health trauma. She likely would still continue to experience, but she has been doing well in school. There will be no other contact with Mr. Montoya and the niece. And we're just asking the court to consider his application for deferred adjudication. If the court does not consider that application, I believe the plea bargain was for a cap of 7 years. We're asking the court to possibly consider a downward departure and placing him in TDC for a lower amount of sentence opposed to the 7 years.
All right, is there anything you wish to say?
I do accept responsibility for my actions.
All right, just 1 second. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God? That's it.
Yes.
All right, you can lower your hand, state your name for the record.
Hey, Montoya.
All right, so is why? Why did you do this? And the reason why I asked that question, because that's a part of, I think, an introspection, right, to yourself. So why? And I think sometimes understanding why we do certain things will help us not repeat it if it should not be repeated. So why?
Why? I believe I do need more self-reflection to understand as to why it was something that should have never been have done. Going through my own depressive episodes and self-loathing, I would say I have caused myself to go down a spiral of deep creativity, I believe.
Mhm.
However, I am able to bounce back up and to truly self-actualize myself. As to why, I fear that it may be because I'm also myself a victim itself, and I understand that it happens because of that, that kind of thing. I'm still trying to come to terms as to why, basically. I don't like saying I don't know yet,
Okay.
but it is something that I do regret. I have lost something precious to me. Understand?
All right.
That's all I can say.
All right. Any questions from the state?
Not necessarily.
All right. Thank you. I appreciate your testimony. All right. This is what the court is going to do. The court is not going to grant your application. The court will find you guilty. This will run concurrent with County Court Cause Number 7344433. There's to be Chapter 62 compliance. There's to be no contact with the complainant. There's a $1,500 fine, time and money run concurrent. Court will give you credit for any time served. I am unsure if the therapeutic community, if you will qualify for it. I'm going to request it for you because I think there's some mental health issues and some trauma going on with you based upon what has happened to you and based upon what I read in the PSI report that he has brothers who are in prison for the same thing, and one of the brothers was actually a perpetrator of him. And the court will sentence you to just 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not with regards to sentencing, Your Honor, we do have the behavior.
All right.
Not from the defense judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. With regards to the therapeutic community, you will still have to request that. It doesn't increase the time that you're in custody, but it can help you, I would say, deal with your past trauma. You understand? I do appreciate that you accepted responsibility for this. Sometimes people never accept responsibility. Sometimes they blame other people for their actions. Is calling. 2023 CR 8695, State of Texas versus Paul Anthony Perez. Can I have parties announced for the record for the state? Defense?
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Pettis.
And are you Mr. Perez?
Yes, Your Honor.
All right, you entered a plea of no contest on October 24th, 2023 to the offense of aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. There's an affirmative finding of deadly weapon, and the state is silent on your application, and there's to be restitution. Have both parties had a chance to review the PSI report, state?
No, I haven't. I was unaware that Mr. Sandoval was here.
Okay, no problem. I think we only requested the TAP evaluation and criminal
Yes.
history.
That'd be fine.
Yes, Judge.
And so, do y'all have criminal history to tender to me? All right. If y'all need time to get that, I can call the next case. All right, no problem.
Your Honor, if I may, on behalf of Mr. Pettis and for efficiency purposes, Your Honor, although PSI was not done, the TAP evaluation was done. And there was a notation on there about him being slightly motivated for treatment. And in my discussions with Paul over the last 6 months, shortly after him just turning 18, being arrested for this, he's well aware that his future is at a crossroads, that his entire life is at a crossroads, and that the activity with respect to substance abuse and his experimenting with that needs to change. That was not in and of itself the reason for what gave rise to this incident. Through no fault of his own, financial hardships led his family to living in a, for lack of a better term, a group home, which was a highly stressful situation. Mr. Pettis has reflected upon all this. As I said, he had just turned 18 upon his arrest. He's been in custody for 6 months, will not turn 19 for another 6 months.
So counsel, let's just wait until the state is ready to give me the criminal history.
Well, okay. Well, I would just inform the court with respect to the slightly motivated portion of the TAP evaluation. Oftentimes it comes across as the lack of motivation, where what's really intended is he doesn't want to be a problem to anyone.
All right.
Judge, I'm not sure.
Thank you. Any objections to the court reviewing the?
No, Your Honor. In fact, we appreciate it and
Just judicial dialogue, Your Honor.
All right, thank you.
That's as an adult and then PS and previous juvenile.
All right, counsel, you may continue.
and Your Honor, Mr. Pettis presents himself, and I say Mr., it really should be, as I said, yeah, it should be Master Pettis, presents himself seeking a chance from this court as an adult under the criminal justice system. He has not had an opportunity to prove himself, not to the court or to the state or to myself, but to himself and what he can accomplish, especially given the sword of Damocles which hangs over his head should he fall short, if this court in its ultimate wisdom were to allow him community supervision and the opportunity to turn his life around. I was taken by the court's attention paid to another young man earlier today. As odd as this will sound, Your Honor, it may sound odd to everyone in this courtroom, but what I wouldn't give as a 58-year-old male to be in Mr. Pettis's position right now, even though he's in an orange jumpsuit and in handcuffs, he's 18 years old and he has his whole future ahead of him. And what I wouldn't give to be 18 again. And if he only knew now what I know, and what we, the judge is far, far away from my advanced years, but what we now know. And it's, given the totality of the circumstances of this young man's life, society would not be harmed, given the localized tension that gave rise to this event, and him being given an opportunity. And if that opportunity also includes, we've discussed, Mr. Pettis and I, the necessity of some sort of substance abuse treatment, even inpatient, to begin the process, to allow him to, again, not prove himself to this court or myself or Judge Garahan or anyone else, but to himself that this is not him. And it does not have to be him, nor does it need to define him. And Mr. Pettis presents himself to this court. Should the court have any inquiry, or should Judge Garahan have any inquiry of him?
All right. State, you're silent on the application, but according to the plea, it's a cap of 6 years.
And it's a cap of 6 years silent.
Oh, and you're silent on the cap as well?
Yeah, yes.
Okay. All right. Has anyone had any contact with the complainant?
He has a previous contact, Your Honor. They're aware of the,
Anything you wish to say, Mr. Pettis?
I just want to say that I know what I did was wrong. I'm very sorry.
So can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Paul Pettis.
All right, so what were you two arguing about?
We weren't arguing about nothing. I literally just got out the shower and he attacked me.
That's not what it says in the stipulations.
That's what it should say.
That's not what it says. Do you want a jury trial?
No, I don't.
All right, so according to the stipulations, it doesn't say you were outside and he attacked you. So you say you just got out the shower and that's when he attacked you. I need you to say yes or no.
Yes, Your Honor.
All right. So you just get out of the shower, and I'm assuming you're nude because I don't know anybody who showers with their clothes on normally. So you were showering with no clothes on. Am I to assume that?
Yes, ma'am.
All right. So immediately upon getting out of the shower, did you have a chance to grab a towel or anything of that nature?
Yes, ma'am.
All right. So you grab a towel. Did you have a chance to wipe off with the towel, or did you just have it wrapped around your body?
I had a chance to dry myself.
So you dried yourself. Did you have a chance to put on clothing?
Yes, Your Honor.
So you put on your clothes. So when you say he immediately attacked you after you got out of the shower, did this happen in the bathroom or where the shower is or no?
And I got out the restroom.
All right. So you're in the restroom, and immediately when you walk out the restroom door, that's when you're saying he attacks you?
Yes, he said, "What's up, local?" And I said, "What's up?" And then I turned around and he already had his shirt off and attacked me.
So had you stepped out of the bathroom when he attacked you?
Yes, I did.
All right. So I'm assuming that your bathroom does not have knives. Did you have a knife in your pants?
I did not.
All right. So where does the knife come in? Because he got stabbed.
I'm not sure.
Well, I mean, it says you had a knife. So from the time you're saying he attacked you in the bathroom, you dry out, you come out, there are no knives in the bathroom. So where did you get the knife?
I don't think it was a knife. I think it was scissors.
All right. Okay. Is there anything else?
Your Honor, on behalf of Mr. Pettis, again, this living arrangement judge, due to the financial circumstances his family was going through, was very tension-filled. Whole bunch of folks living in and it's no excuse. As he said, he apologizes for his action. And listening to the court's dialogue with Mr. Pettis, for clarification purposes, I want to stress that Mr. Pettis is relaying these facts to a court with an 18-year-old's mindset, in not seeking justification, Judge, but just seeking some path to the best outcome possible. I don't, and no deception. And this is from my 6 months of working with Mr. Pettis and having visits with him. He's always come across as very articulate, very polite, very courteous, and has helped me in structuring possible defenses. As the court may be aware, there was a time where Mr. Pettis came forth and explored the possibility of maybe seeking other counsel, and we worked through that. And so he's maturing, and I believe that given the opportunity, that path of maturation can continue.
All right, Mr. Pettis, I want to let you know that I listened to everything you said. I always reread everything and look at everything, and I'm taking in consideration your age. But according to the police report that I reviewed, the complainant got stabbed and it went through his lungs. Could have died, right?
Yes, Your Honor.
So I'm not going to grant your application. I'm going to find you guilty, but taking in consideration your age, I am going to sentence you to 4 years in the prison. The state will add a cap of 6 years. Give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Omar Morales Sastre, S-A-S-T-R-E. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And counsel, if you think it's appropriate, I'll request for him to be placed in the therapeutic community to address any mental health issues, if he has any, or drug issues.
Your Honor, any courtesies that can be extended by this court and its wisdom would be appreciated.
All right. And Mr. Pettis, you'll need to request the therapeutic community as well for them to even consider it. You understand?
Yes, Your Honor.
All right. We can go off the record. I realize that you're very young. I realize that going to prison or either going to the Bexar County Jail, any time that you do where you're not free is a lot of time, even 24 hours. But
Welcome to Global News Desk. In today's courtroom case, Nathan Montoya appeared before Judge Stephanie Boyd, hoping to receive deferred adjudication instead of a prison sentence. His defense argued that he had no significant prior criminal history, had been working at Amazon, accepted responsibility, and had already spent time in custody reflecting on his actions. His attorney asked the judge to give him an opportunity to turn his life around. But Judge Boyd wanted to understand something deeper. She asked Nathan a simple but important question. Why did you do this? Nathan struggled to give a clear answer. He talked about depression, self-loathing, personal struggles, and needing more self-reflection. He admitted that he regretted what happened and understood that his actions were wrong. But the judge appeared concerned that he still could not fully explain why the offense happened. The defense continued asking the court for mercy and requested deferred adjudication. But the state opposed the request. After hearing everything, Judge Boyd made her decision. She denied deferred adjudication, found Nathan guilty, and sentenced him to 7 years in prison. The sentence also included a fine, no contact with the complainant, and other legal requirements. What makes this case especially powerful is the judge's reasoning. She acknowledged Nathan's personal struggles and even requested that he be considered for a therapeutic community to help address his trauma and mental health concerns. But compassion did not erase accountability. This is Global News Desk, bringing you courtroom moments where difficult questions can change the entire outcome of a case. The message from the courtroom was clear. Admitting that something was wrong is important, but sometimes the court needs to see deeper understanding, responsibility, and genuine reflection before granting a second chance. And in this case, the judge ultimately decided that a second chance through deferred adjudication